Ohio comparative fault laws explained by injury law firm. When you are injured in an accident, one of the first things the insurance company may try to do is blame you. They may say you were speeding. They may say you were not paying attention. They may say you could have avoided the accident. But in Ohio, being partially at fault does not automatically mean you lose your right to compensation. That is where Ohio's comparative fault law comes in. Today we are explaining how comparative fault works in Ohio, how it can affect your personal injury claim, and why fault percentages can make a major difference in the amount of compensation you may recover. At Zoll Kranz, we help injured people understand their rights after serious accidents, especially when insurance companies try to shift blame away from the responsible party. What is comparative fault? Comparative fault is the legal rule used to decide what happens when more than one person may share responsibility for an accident. In a personal injury case, the question is not always, who is completely at fault? Sometimes the question is, how much fault belongs to each person involved? For example, in a car accident, one driver may have run a red light, but the other driver may have been speeding. In a slip and fall case, a business may have failed to clean up a hazard, but the injured person may be accused of not watching where they were walking. Comparative fault is how the law assigns percentages of responsibility. Ohio uses a modified comparative fault rule. Ohio does not use a pure comparative fault rule. Instead, Ohio follows a modified comparative fault system. That means an injured person can still recover compensation if they are partially responsible, but only up to a certain point. Under Ohio law, if your percentage of fault is 50% or less, you may still recover damages. But if you are found to be more than 50% at fault, you are barred from recovering compensation. Ohio law says a plaintiff's contributory fault does not bar recovery if the plaintiff's fault was not greater than the combined fault of the other responsible parties. Simple example: how compensation is reduced. Here is a simple example. Let's say your total damages are valued at $100,000. That may include medical bills, lost wages, pain and suffering, and other losses. If you are found to be 20% at fault, your compensation would be reduced by 20%. So instead of recovering $100,000, you would recover $80,000. The more fault assigned to you, the less compensation you may receive. Ohio law specifically provides that compensatory damages are reduced in proportion to the plaintiff's percentage of fault. The 50% line matters. The most important number to understand is 50%. If you are 10% at fault, you may still recover. If you are 25% at fault, you may still recover. If you are 50% at fault, you may still recover, but your damages would be reduced by half. But if you are 51% at fault, you recover nothing. That 1 percentage point can be the difference between receiving compensation and receiving nothing at all. Why insurance companies use comparative fault against you? Insurance companies understand how powerful comparative fault can be. If they can convince you, a claims adjuster, a judge, or a jury that you were partially responsible, they may be able to reduce the value of your claim. And if they can push your share of fault above 50%, they may try to deny the claim completely. That is why insurance companies often look for ways to blame the injured person. They may claim you were distracted. They may argue that your injuries were caused by something else. They may say you failed to avoid the hazard. They may suggest you were not following traffic laws. They may use your own statements against you. This is one of the reasons it is important to be careful about what you say after an accident. Comparative fault in car accident cases. Comparative fault often comes up in Ohio car accident claims. For example, fault may be disputed if both drivers entered an intersection, if there are conflicting statements, or if one driver was speeding while the other failed to yield. Even when the other driver clearly made a mistake, their insurance company may still argue that you share some responsibility. In these cases, evidence matters. Police reports, traffic cameras, witness statements, vehicle damage, accident reconstruction, medical records, and photos from the scene can all help determine what really happened. Comparative fault in premises liability cases. Comparative fault can also come up in slip and fall or premises liability cases. A property owner may argue that the danger was open and obvious, that warning signs were posted, or that the injured person was not paying attention. But property owners still have legal responsibilities. If they failed to maintain safe conditions, ignored a known hazard, or failed to warn visitors about a dangerous condition, they may still be liable. The issue becomes whether the injured person shares any fault, and if so, how much. Comparative fault in product liability or injury cases. Comparative fault may also come up in cases involving defective products, workplace-related third-party claims, or other serious injury cases. A company may argue that the injured person misused the product, ignored instructions, or failed to take proper precautions. These arguments can become complicated quickly. That is why it is important to investigate not just what happened, but why it happened and who had the ability to prevent it. Who decides the percentage of fault? Fault percentages may be disputed throughout the claim. An insurance adjuster may assign fault during settlement negotiations. But if the case goes to trial, the court or jury may be asked to determine each party's percentage of responsibility. Ohio law allows findings of fact or jury interrogatories to specify fault when contributory fault is asserted and established as a defense. This means the way the case is presented can directly affect the outcome. Strong evidence can reduce the amount of fault placed on the injured person. Weak evidence can give the insurance company more room to shift blame. Why you should not assume you are at fault. After an accident, many people blame themselves too quickly. They may say things like, "I should have seen them," or "maybe I could have stopped sooner." But fault is a legal and factual issue. It is not always obvious. You may not know whether the other driver was distracted. You may not know whether a business had received prior complaints about a hazard. You may not know whether a product had a known defect. You may not know whether surveillance footage, maintenance records, inspection reports, or witness testimony could support your claim. Before accepting blame, it is important to understand the full picture. And most importantly, never admit fault to other parties. Anything you say, no matter how benign it may seem, can come back to haunt you later. Talk to a lawyer first and let them handle the conversation with insurance adjusters, witnesses, police, and other parties. What to do if you are being blamed? If the insurance company is blaming you, there are steps you can take. Do not admit fault. Do not guess about what happened. Do not give a recorded statement without understanding your rights. Save any photos, videos, medical records, police reports, and witness information, and speak with an attorney before accepting a settlement or denial. Once fault percentages are assigned, they can have a major impact on your recovery. How Zoll Kranz can help. At Zoll Kranz, we understand how insurance companies use comparative fault arguments to reduce or deny claims. Our job is to investigate the facts, identify the responsible parties, preserve evidence, and push back when blame is unfairly shifted onto the injured person. Whether your case involves a car accident, a dangerous property condition, a defective product, or another serious injury, we can help you understand how Ohio law may apply to your claim. If you are injured in Ohio and someone is trying to blame you for the accident, do not assume you are out of options. You may still have a valid claim. Contact Zoll Kranz today for a free consultation. We can review what happened, explain your rights, and help you determine the next step.